Good afternoon, everyone, and welcome to the CICES presentation this afternoon, hosted by CMS. My name is Ewan Wilson, and I'm an associate in the construction and engineering team at CMS based in the Glasgow office. I'm joined today by two of my colleagues, firstly by Martyn Stevenson, who is also an associate in the construction and engineering team in Glasgow, and by Amy Roberts as well. Amy is an associate in our infrastructure, construction and energy disputes team as well, so full Glasgow contingent for you this afternoon. During this event, we're going to discuss the Housing Grants, Construction and Regeneration Act 1996. I'm sure most of you will know it as the Construction Act. And the Construction Act came into force in 1998, so this year marks the 25th anniversary of it coming into force. So we thought it would be a good opportunity really to consider the issues prior to the Construction Act coming into force, the revolutionary changes that the Act introduced, notably on construction contracts, construction operations, introducing payment mechanisms and adjudication as well. And lastly, we'll be looking back and assessing overall the effectiveness of the Construction Act and what's more to come in terms of transformative legislation as well. So before we begin today's session, just a couple of housekeeping bits and pieces as well. A copy of our slides that should hopefully be appearing on your screen just now should arrive with you after the webinar has finished as well, so you'll get a copy of those. The webinar will also be available to view afterwards on the CICES YouTube page as well. So if you go there, you'll be able to rewatch the full webinar itself. And lastly as well, time permitting, we're going to take your questions today as well at the end. So there should be a chat box that will appear on your screen. At any point throughout the session this afternoon, you can include some questions or some comments in that as well, and we'll do our best to pick them up at the end. And that's not something you have to wait until the very end of the session, it's just you can do it throughout. So please do put your questions there as well, and we'll do our best to pick them up. So without further ado, I'll hand over to Amy, who's going to take us through a bit of context and a bit of background on the Construction Act before we delve a bit deeper into the provisions and the things that it introduced.
Thank you very much. So as you will all no doubt be aware, back in the early 1990s, the most commonly used standard form of contract in the UK was JCT 80. From my point of view, the dispute side, this contract provided for arbitration in clause 41, for anyone wondering, and this often couldn't actually be commenced until after practical completion, termination, or abandonment, unless the parties agreed otherwise. At the time, arbitration was a very lengthy procedure and was similar to court. Under NAC, there was provision for adjudication, however, it wasn't like the statutory form that we now know. In addition, there was no statutory payment provisions, and there were no definitions setting out what construction operations were or what construction contracts were. Cue Sir Michael Latham's report, Constructing the Team, in July 1994. It's now known as the Latham Report. Now, a key driver of this report was the need to keep cash flow moving between parties. This ultimately led to the Housing Grants, Construction and Regeneration Act of 1996, which sought to codify what a construction contract was, the meaning of construction operations, providing statutory payment provisions and construction contracts, whilst also allowing for statutory adjudication at any time. As you well know, and as Ewan's mentioned, this came into force in 1998 with some amendments throughout the years. This included the Local Democracy, Economic Development and Construction Act 2009. This came into force in England and Wales and amended adjudication and payment provisions, as well as led into a new scheme, and this all came into force on the 1st of October 2011. The three main changes under this were a new payment regime, including the introduction of new default payment notice. The previous withholding notice was replaced with a pay less notice, and this was all given teeth in that they led to an entitlement to pay. There is an enhanced right of suspension and some limited changes to the statutory adjudication process. So, as Ewan said, we're 25 years on. What is it that's changed in that time? What came into force? That's exactly what we're going to be looking at today, and also looking ahead into the future.
Thanks, Amy. So we'll start off by looking at the payment mechanisms of the Act. As Amy has just mentioned, the Act codified a number of things, such as the definition of a construction contract and construction operations, but it also provided statutory payment provisions. As a brief bit of background, and to build on what Amy has already mentioned, prior to the introduction of the Act, parties negotiating construction contracts didn't have black letter requirements governing how their payment provisions should be formulated. The Act introduced a statutory requirement for construction contracts to have a clear, transparent and straightforward payment mechanism. So with the topical issues that the construction industry is facing in respect of cash flow issues, stock shortages and other hurdles attributed to the coronavirus and the war in Ukraine, the key problems that the Act looked to alleviate, being the importance of protecting the supply chain and ensuring fair and regular payments, are still as relevant now as they were 25 years ago when the Act first came into force. So going back to the application of the Act, I'm not going to recite the base payment provisions the Act incorporated, as these can be found in the Scheme for Construction Contracts, which sits alongside the Act and supplements it by providing the backup payment provisions. There'll be a link to the scheme available in the materials section. So what the Act did introduce was a requirement that contracts have, to quote the Act, an adequate payment mechanism. And in order to satisfy that requirement, the contract must make clear what payments become due under the contract and when. It required parties specify a due date and a final date for each payment under the contract, and the scheme provides for minimum timescales that the payment regimes under those contracts are to comply with. They're also introduced that payments are not to be conditional on the performance of obligations under another contract or a decision by any person as to whether obligations under another contract had been performed. So what the Act essentially looked to do was to strike out pay when paid clauses. Although, as Ewan is going to discuss later, if the Act has ultimately been successful in this is still open to some debate. The final concept in this respect that I'll highlight that the Act introduced was a right to interim payments if the works under the contract are for 45 days or more. The Act isn't prescriptive in how parties agree to this, so long as the mechanism again complies with the overall requirement of an adequate payment mechanism. So I'm briefly going to touch on a case that highlights that last point quite well. The case is Grove Developments versus Balfour Beatty, and it highlighted the importance of ensuring that parties to a contract understand what they are agreeing to in respect of inserting specific payment arrangements. The parties in this case agreed to a payment schedule detailing 23 interim payment applications and payments. However, the contract did not deal with what would happen in the event that the contract was delayed. The court held in this case that Balfour Beatty had no contractual right to make or be paid in respect of interim payment application 24, or to make an application for further payments until the contract's final payment mechanism kicked in after practical completion. The key point I think to take away in respect to the payment provisions of the Act is that should your construction contract either not contain payment provisions or more likely contain payment provisions, but these do not comply with the base provisions contained in the scheme, then the relevant provisions of the scheme will be deemed to apply. This point and the outcome of some of the cases that I've highlighted I'm going to mention reiterate the need for both parties to be fully aware of the payment provisions and mechanisms their contract is going to be governed by. So this can become a bit messy, as recent court decisions have confirmed that payment provisions from the Act don't need to be applied wholesale. Coulson LJ stated in the case of Bennett Construction Limited versus CIMC MBS Limited that a piecemeal incorporation is permitted, and he stressed that the wholesale replacement of a contract's payment regime should only be necessary in exceptional circumstances. So what the court's looking to do here is they're not looking to apply the base provisions of the scheme wholesale into a payment mechanism that the contract has. The courts are very reluctant to read into contracts what parties haven't agreed. So if two parties have agreed a payment regime, the courts will do their utmost to maintain that payment regime. However, if that payment regime isn't compliant with the Act, the base provisions of the Act will apply in those situations. So as I mentioned, if the construction contract didn't contain any payment provision, then the scheme's payment provision would apply wholesale. But there's a more likely scenario where some aspects of the construction contract's payment provisions are Act compliant and some are not Act compliant. And in those scenarios, only those elements of payment provisions which are not Act compliant will be read into the contract. So to take an example, the provisions in relation to interim payments and due dates may be Act compliant, but the provisions in relation to final dates for payment may not be. And in that scenario, only those parts of the scheme relating to final dates for payments would be read into the contract. So to touch very briefly on a recent case that Baxter's point up, Lidl Great Britain versus closed circuit cooling, which the judgment came out fairly recently. It's a 2023 case. In this case, Lidl and closed circuit cooling are trading as 3CL entered into a framework agreement which entitled 3CL to make applications for interim payment. 3CL issued an application for payment, and following receipt of this, Lidl issued a response which valued the works at nil and included the claim for liquidated damages. There was a disagreement as to whether this is a valid payment notice, but what I'm going to touch on is a debatably more interesting aspect of the case, in that there was a disagreement between the parties as to whether the final date for payment was Act compliant. So the judge in this case sought to rely on a previous decision, which is Rochford v Kilhan, which held that a final date for payment is to be linked to a fixed date and not a floating date. So for this example, the final date for payment couldn't be fixed to the production of a VAT invoice, as this was not a fixed date. This was a date that would change from month to month depending on when the VAT invoice was produced. This is something to be aware of when looking at the payment provisions of construction contracts, as quite often final dates for payments are linked to those production of invoices, and are sometimes a requirement is that the invoice is produced before the final date can be set. So what this decision reiterates is that in that scenario, this will not be Act compliant, and in those scenarios, the scheme's provisions in respect to final dates for payment would be read into the contract. So what the above case highlights is that the only certain aspects of the scheme will apply if only parts of the payment mechanism are not adequate. This can cause confusion and potentially result in missed payment deadlines. So our advice here is, as I mentioned earlier, is for both parties to think carefully around the payment provisions of the contract and seek advice on the adequacy of the provisions in light of payment provisions contained in the scheme. Like with most contractual terms, things can work well until they don't, and if you are to find yourself in a position where a dispute is potentially going to occur, then having more clarity over what the payment mechanism is in the contract and a better understanding of its compliance with the Act will help give a stronger base to resolve any potential dispute. So moving on from that, and moving on from payment mechanisms, Amy also mentioned, and Ewan had kind of touched on, in addition to the payment mechanisms that the Act brought in, the Act also sought to define what was a construction contract and what was defined as construction operations. Now, this is a key point to remember, as only contracts that fall into the definition of a construction contract under the Act are governed by the Act, and therefore only if the contract falls in that definition does the Act's payment provisions apply. And also, Amy's going to talk about adjudication provisions, and again, those will be read into construction contracts, but only those which fall under the definition of the Act. So the definition of a construction contract is set out at section 104 of the Act, and it encompasses all agreements, including professional appointments and subcontracts, under which construction operations are carried out, also specifying that it includes agreements to do architectural, design or surveying work, or to provide advice on building, engineering, interior or exterior decoration, or on the laying out of landscape in relation to construction operations. Now, the interesting part here is how the Act defines construction operations at section 105 subsection 1. It's generally given a wide application, and the Act specifically includes construction, alteration, repair, maintenance, extension and demolition or dismantling of buildings or structures forming or to form part of the land. The subclauses then list quite specifically what these include. I'm not going to list these out verbatim, but again, a copy of these sections of the Act is available as a download in the materials section. The Act also specifically excluded certain works from construction operations. At a high level, these include drilling for or extraction of oil, mining, and works relating to nuclear power generation. The full list is set out in section 105 subsection 2. With the Act distinctly excluding certain activities from the definition of construction operations, and therefore excluding certain activities from being governed by statutory payment provisions, this has proved problematic in respect of hybrid contracts. Now, a hybrid contract in this context is a contract which straddles those operations which are deemed construction operations under the Act and those which fall outside of the definition of construction operations. Contracts can often involve a mix of works, and in some scenarios, only some elements of the works would fall under the definition of construction operations. Now, where a hybrid contract exists, it's key that that contract contains an Act-compliant payment mechanism, as if it doesn't, the scheme would only apply to those operations which are covered under the definition of construction operations. Employers or clients may therefore find themselves in a situation where they have two separate payment mechanisms covering separate operations under the contract. And you can see how this can get quite messy. As I've alluded to before, the courts aren't looking to read wholesale payment mechanisms from the Act. So you may have the situation where part of the payment provisions are Act compliant, parts aren't Act compliant, but they only apply to the construction operations as the definition of construction operations under the Act. And this is where I've reiterated before, but taking advice on what does and doesn't fall under construction operation and what is and isn't Act compliant in terms of payment mechanisms can make things a lot clearer. So I'm going to highlight, I'm going to touch on a case that highlighted the court's view on this point, being Severfield versus Duro Felguera. And in this case, Duro had engaged Severfield under a contract to carry out the design, supply and erection of steel structures on a site in Manchester. So in this scenario, or in this case rather, some work comprised of construction operations under the Act, but some related to power generation and so were specifically excluded from the provisions of the Act. The parties had agreed the payment regime under the contract, but this payment regime wasn't Act compliant. Severfield made an interim payment application for approximately £3 million, although such payment application did not divide the work between what were deemed to be construction operations under the Act and which weren't covered by the Act. Duro then failed to give a valid payment notice or a pay less notice, and so Severfield adjudicated for the amount due. The adjudicator awarded the sum claimed to Severfield, and they subsequently applied to the court for summary judgment to enforce that decision. However, the court refused to grant summary judgment on the grounds that the adjudicator did not have the jurisdiction to decide upon those amounts claimed in the payment application relating to the services that were not construction operations as defined under the Act. Further, the figure claimed in Severfield's interim application was not broken down into sums due for construction operations and those sums which were not due to construction operations. Had they been, Severfield may have been able to argue that the adjudicator did have jurisdiction to decide upon those sums due in relation to those construction operations. However, the adjudicator decided on the whole lump sum, and so the court found that the adjudicator would have been obliged to apply separate payment regimes for those operations which were inside the Act and for those operations which fell outside the Act. The result of this case highlights the importance, and I've mentioned it before, of ensuring that you have a payment regime which complies with the Act insofar as it has to. Now, parties may wish to agree non-Act compliant payment regimes for operations, or they may wish to agree for Act compliant payment regimes for all operations under the contract. But if, for whatever reason, the intention between both parties isn't for the contract to contain Act compliant payment regimes, this needs to be made extremely clear in payment applications for operations which are not under Act compliant construction operations. And for those that don't.
Thank you, Martin. I think that leads us on quite neatly to adjudication provisions under the Act. So as I mentioned at the start, the Act brought in the statute adjudication, and as Martin's mentioned, the Act incorporates the scheme for construction contracts. There's one for England and Wales and a separate one for Scotland. It's section 108 of the Act that sets out the adjudication provisions, and this is what allows parties to construction contracts as defined and as covered handily by Martin to refer any dispute to adjudication at any time. Now, if the construction contract does not provide fully for these provisions, again section 108 subsections 1 to 4, then unlike the payment applications where the gaps can be filled, as Martin mentioned, the adjudication provisions in the scheme do apply as default. Or parties can just choose to incorporate the scheme in their construction contract as a way of covering these off. So the scheme set out lots of different powers and issues that were really being faced by the industry at the time. These included, but weren't limited to, timescales for submissions and the adjudication itself, the powers of the adjudicators, and also the effects of the adjudicator's decision. So as you'll be aware, I'm sure you've heard us lawyers say this all the time, but adjudication is known as the rough and ready dispute resolution procedure. And that's mostly due to the tight timescales. Under the Act, this can be as quick as 28 days from your referral notice to a decision, although extensions can be agreed. This is clearly very different from arbitration in court, whereby disputes can continue for months, if not years, and can also be extremely costly. So it comes back to the cash flow that was considered in the Latham report. Projects. So we do continue to see adjudications being used very and we're also seeing an increase in alternative dispute resolution, including mediation and or expert determination. Now, the pros and cons for adjudication are largely the same, but they have been impacted on by the progress of adjudication over the last 25 years. One of these is the fact that there's quick decisions. As I mentioned, it can be as quick as 28 days from referral to decision. However, what we've seen over the last 25 years is that adjudications are taking longer and longer, with many of them lasting many, many months. This is obviously not the original intention of the Act, and arguably it could be that such disputes might be better suited for the court. However, that would obviously cause an issue because the adjudicator would still have some sufficient jurisdiction there. One of the other probably pros and cons of adjudication is that the decision is interim binding. So that means that the dispute can be rerun in arbitration or court, depending on your contract. I have to say, we see a reluctance sometimes to do that, especially if there's a complex and lengthy adjudication that's just taken place and has therefore cost a fair amount of money to do so. That moves on quite well to the fact that adjudication is still seen as the cheaper option, and that is still true. However, given that adjudications are getting lengthier and lengthier, the cost has increased. And as you will all be aware, the costs are also borne by the parties unless there's an agreement otherwise in writing before the adjudication is raised under section 108A of the Act. In comparison, courts and arbitration are usually allowed for some recoverable expenses for the successful party, although this is usually somewhere between 40 to 60%. And we've also got the adjudicator themselves. So this can be someone within the industry, the benefit being that that is someone with a technical background. However, that comes with some drawbacks in itself, because you're largely relying on the person to have a good quality of skill and decision making. Now, all of that being said, there has been a shift in the industry in the last 25 years, and that's been one away from disputes and towards dispute avoidance. There's been numerous changes over the years that has really demonstrated that, and I'd have to say that moving forward, it may well lead to a reduction in adjudication referrals. So some of these changes include the fact that there's been a move away from ambush adjudications. So we've got, those are the adjudications that come out of the blue, or those friendly ones that land on Christmas Eve and ruin your Christmas holidays. Now we do see them from time to time still, and they're useful when you're trying to force the hand of the other party. But the difficulty is that even for an ambush adjudication, the dispute must be crystallised between the parties before the trial. We've also seen a slight rise in dispute boards being appointed at the outset of contracts. to assist parties in identifying emerging issues and coming to a resolution where a dispute has arisen. This includes the introduction of the DAB within JCT in 2021, which was the first attempt to make an Act compliant DAB. So this was meant to be proactive rather than reactive, and a mechanism to resolve disputes whilst also allowing for adjudication where or if required. But I have to say, DAB are still used more regularly internationally. What we're seeing from the government as well is policy notes which do push towards this collaborative working. So back in 2021, there was actually a policy note issued called conflict avoidance in the Scottish construction industry. So that obviously shows the trend towards this collaborative approach together. And you'll no doubt all be aware that during COVID, there were lots of policy notes, both UK government and Scottish government, that did that as well. From a drafting point of view, we're also seeing an increase in the use of escalation clauses. This can be done in bespoke contracts, but also some of the standard forms. And again, I think this is something we're really going to see an increase of, and perhaps including mandatory mediation. Now, a good example of an escalation clause is NEC4 option W2. This sets out that disputes should first be referred to the senior representatives. Then, if there's no agreement between the senior reps, that can then be referred to adjudication and then on to tribunal, which is typically the court. Now, the first step itself is not mandatory, but the escalation from adjudication to court is. So it's key to just make sure when you're drafting contracts or when you're in a dispute, that you make sure you're complying with any mandatory or voluntary escalation clauses. Whilst on the topic of NEC, another move towards collaborative working can be seen in our well-known clause 10, which sets out that the parties, the project manager and the supervisor should all act in the spirit of mutual trust and cooperation. Now, over the years, there has been a raft of case law following the Act, and particularly in relation to adjudications. I'll touch on some of the kind of key areas now, but I appreciate Martin's already spoken about payment provisions and also those on hybrid contracts. One of the key aspects for those particularly dealing with jurisdictional challenges is dealing with the definition of the dispute, which is always in the singular, and the fact that it should be given its normal meaning. It's not for a special or unusual name to be compared by lawyers. And also the fact that the dispute itself has crystallised. So we're still looking at the AMEC civil engineering against Secretary of State for Transport and fast track contractors against Morrison construction cases for that. It's also well known that an adjudicator can err in law and fact. That has been the case for 23 years, and it ties in with the rough and ready nature of adjudication. However, a key question that the courts often consider is whether the adjudicator had the requisite jurisdiction. So that's definitely something to consider. Moving on to a well-known case that came out last year and has just recently been overturned, we have Global Switch Estates against Subcos. This related to serial adjudications, which is certainly a hot topic in the industry. Particularly, now what is so key about it is that the principle that a dispute cannot be referred to adjudication where it is the same or substantially the same as one which has previously been referred and decided on, and that's referred to in the scheme itself. So in the decision that came out this year, 2023, the TCC agreed with the initial analysis of the adjudicator and found that in fact a different delay period was an issue and that new evidence had been presented was not sufficient to render the dispute different from the previous adjudication. So the court found that the need for speed and temporary finality, coming back to our interim binding nature of the decisions, means that adjudicators should be encouraged to give robust and common sense answers to questions of binding force. It shouldn't actually be a complex question of interpretation of documents and citation of authority. So I think that's trying to pull it back to what was really intended by the Act. Now, another hot topic in terms of case law is that of smash and grab and true valuation adjudications. I'm sure you'll all be well aware, but a smash and grab adjudication is one where a party fails to issue a valid payment or pay less notice, and that is deemed acceptance of the payee's application. And that's been since 2014. We've got ISG Construction against Civic College. However, then came 2018 with S&T against Grove Developments. And this provided that a paying party is entitled to adjudicate on the true value of the payee's interim application, even where there's been a successful smash and grab. Now, this has been criticised both at the time and throughout due to the principle of this. There's been further case law on this, but most recently, again in this year, there was Henry Construction Projects against Alu Fix. In this case, a contractor commenced a true value adjudication while the subcontractor smash and grab adjudication was ongoing. The subcontractor was successful in the smash and grab, and the true value was stayed pending payment. Thereafter, in the true valuation, the contractor was the successful party. Accordingly, they applied for summary judgment to enforce the true valuation. However, the subcontractor argued that as the true valuation had been commenced prior to the satisfaction of the immediate payment obligation, the adjudicator had no jurisdiction. Now, the finding of the TCC in this case clarifies that in the majority of cases, failure to pay a notified sum deprives a party of the contractual right to commence a true valuation adjudication, and an attempt at such adjudication will lack jurisdiction. However, there might be some limited circumstances in which a party can commence that true valuation adjudication without having made payment. Now, what this case did not clarify was the bar on which commencing a true valuation adjudication applies. There's also some outstanding queries around potential windfall scenarios, for example, where employer insolvency scenarios occur. So no doubt this is not the end of smash and grab and true valuation case law, and I think we're keeping our eyes peeled to make sure that we're looking out for the next law. Finally, just a flag that's still, again, a hot topic in the industry is that of insolvency in adjudication. Now, there was a case in 2021, which was John Doyle Construction against Erith Contractors. The court's judgment makes clear that decisions in favour of companies in liquidation will only be enforced in rare circumstances, such as where the decision has become finally binding due to failure to serve a notice of dissatisfaction. The court's comments in this case could also mark a decline in assignment of construction claims from insolvent companies to litigation funders. Now, what is clear from this case is that insolvency and adjudication are complex areas of law, and there's still uncertainty here. So I think what we'll be looking out for and what will be welcomed is some more case law on this, particularly where we're seeing more insolvencies in the market.
Thanks. I mean, that's really helpful, and I think that's a really comprehensive breakdown of adjudication as it has been impacted by the Construction Act and updated and sort of taken forward through various cases, and some of them very recent as well. Just touching back then, I suppose, as we look back 25 years on from the enactment of the Construction Act, I suppose it's worthwhile just considering actually how effective has the Act been in doing the things that it set out to do. And I suppose with that in mind, Amy's already at the beginning of this afternoon's session touched on the Latham report. and the overall aims that the Act set out to do, specifically with cash flow, I suppose, is the main driver. And I think it's fair to say that the Latham Report and the Construction Act were ahead of their time. And we can see that through the ways in which they introduced and recommended concepts such as enhanced payment mechanisms, recommended adjudication as a normal form of dispute resolution, and the coordination of project information as a contractual requirement as well, and having that focus on information collation. And I'm sure it's been pointed out before as well, but that's at a time where CDs were replacing vinyls, and we had 4 UK terrestrial TV channels as well. So certainly ahead of its time in many respects. When it comes to payment provisions, I think overall the Act had a positive impact, or has had a positive impact on supply chains by the introduction of prescriptive payment mechanisms, due dates, final dates for payment. Cash flow has always been a key driver in how the construction industry operates, but I don't think that will be a surprise to anyone on the call this afternoon. And really the Construction Act, the initial impact of it was to assist those further down the supply chain, to the contractors and to subcontractors. Contracting parties nowadays are generally au fait with the terms of with the Act, specifically when it comes to payment, I would say, and the Construction Act compliant payment provisions are contained within all standard forms of construction contract as well. So undoubtedly the impact has been an effective overhaul of payment provisions across the industry. However, that being said, cash flow is still of critical importance, and one of the biggest issues really affecting the industry, and specifically those towards the bottom of the supply chain, more than 25 years on now. There have been attempts to amend the Construction Act to assist in easing the strain of cash flow, not reaching those further down the supply chain. And there have been attempts to try and legislate that and introduce new legislation with that in mind. So specifically, we had the Construction Retention Deposit Schemes Bill, which I know has been mooted a while. That's currently held up in the legislative process at this point in time, and has been for a couple of years now. And I suppose there has been quite a lot for Parliament to try and contend with in the last, say, 3 to 5 years. So that's maybe understandable, but I think it is indicative of the fact that the Construction Act wasn't necessarily a silver bullet when it came to cash flow and stopping the problems that the Latham Report identified initially all those years ago in 1994. In terms of now, I think we still have tightening margins, so the effectiveness of the changes brought in by the Construction Act can be diluted as well by some creative drafting as well, that when you strip back some payment provisions that are bespoke, they do actually effectively actually in practice, when you break them back, they do enact a pay when paid approach. And while construction compliant or Construction Act compliant payment terms are prevalent throughout all the sort of standard forms of construction contract, they aren't necessarily when it comes to terms and conditions as well. So if people aren't entering into contracts based on standard forms, but are basing them on their own terms and conditions, or are basing them on bespoke contracts that don't have Construction Act provisions, then that's still something that I think is relatively common. And as Martin said earlier, it's absolutely fine until it's not. So it's something to be aware of as well. And I think these are all behaviours that the Construction Act tried to take us away from, but I don't think we're quite there just yet. In terms of the other material change that was introduced by the Act, as Amy's talked about as well on adjudication, I think that the changes brought in by the Act were generally welcomed. I think parties were being encouraged to move to alternative forms of a resolution as well, and away from that more adversarial approach and approach to dispute avoidance. And I think that's something that the Act certainly encouraged, so there has been a bit of success in that regard. However, the sheer volume of adjudications can be problematic, and it can be a tool for contractors to deploy more often than not. Many adjudications are incredibly complex, as we've heard from Amy, and also some of them have cross-jurisdictional aspects to them as well, so not particularly straightforward and not necessarily quite what the Act envisaged in terms of something that's quick and cheap as well. That's not necessarily the case. The trend, though, that the Construction Act encouraged towards this alternative dispute resolution and the adoption of more collaborative approaches to contracts can be seen through particularly the NEC suite, as Amy touched on, and also the prevalence of alliance agreements as well. We've seen a tendency to incorporate wording in commercial contracts, which allows for an incremental approach to disputes, and early warning wording, escalation wording, to sort of manage disputes in a more proactive and commercially viable manner as well. And as we mentioned, probably the most prevalent one that most people sort of think of in that regard is W2 and the NEC suite of contracts. The more collaborative approach that's been championed by NEC is certainly welcome. However, it must be sort of brought with a bit of a pinch of salt as well, in that the Construction Act consultation and that was published in 2020 had I think NEC at around 13% of the sort of contract share for the contracts that were being entered into in the UK. So in that regard, whilst the sort of dispute avoidance and escalation wording that's really prevalent in NEC is great, it's not necessarily indicative of practice across the wider UK construction industry. I think as well, when we're looking at the effectiveness of the Act today, I think it's worth considering the key role that robust project management and record keeping have in applying, managing, and crucially as well in avoiding disputes as they apply to construction contracts that fall within the scope of construction operations in that section 105 of the Act. And that's something that might seem quite obvious, but it really can't be overstated, so I'm going to say it again. The Act was effective in offering clarity in respect of payment and adjudication, but there are gaps there, particularly when it comes to scenarios where the Act doesn't quite perfectly, or the construction provisions and payment mechanisms in particular that are within the contract aren't quite compliant with the Act, and part of them is so that the scheme is partially brought in, and that's really where confusion can come out. So in that respect, it has been effective to an extent, but the waters can still get muddied where contracts are not managed or not drafted with that in contemplation. As Martin mentioned, that's really comes into the fore really with hybrid contracts where there's a mix of works, that only elements of the works fall into that definition of construction operations. So in terms of making sure that your contracts are effective, it's absolutely vital to recognise that, to ensure that all payment terms across the contract are Act compliant. Otherwise, that partial application of the scheme will breed confusion, and you'll get something like the Severfield case where it just turns into a bit of a myriad of picking out where the construction operations are and having more than one payment application process throughout your contract. In terms of future changes that we could see, I suppose with all that in mind, and particularly with hybrid contracts, I suppose that the radical approach, which has been mentioned before, is that where you have a contract that has some elements of the works that are construction operations under that section 105, that you automatically lump in everything as a construction operation if it's in that contract, and that the Construction Act terms apply wholesale. That's something that has been suggested in the past. And while that would potentially make life a lot easier, and you wouldn't have these situations where you have to be very careful about your payment mechanisms, I don't necessarily see that that's actually something that is going to realistically come into force or something that's going to change in the near future, particularly as Martin touched on earlier, Section 105 of the Act in the construction operations part has specific exclusions to construction operations, and the background to that really is that at the time the Act came into force, certain sectors lobbied for that and for certain elements to be excluded. So really, if you were to try and radically change this part of the Act wholesale, I think it would almost go against the spirit of the Act and when it was brought into force. So the sort of key takeaway there is that hybrid contracts are here to stay, and you have to be incredibly careful when you're looking at your construction operations and what falls into that category and what does not. That's not necessarily, I wouldn't say, a deficiency on the part of the Construction Act itself. I don't think that's something that the Act's been ineffective in doing. I think it just means that it requires greater vigilance from drafters, contracting parties, from project managers as well. So overall, I think the Act has been reasonably successful in what it set out to achieve. The changing attitudes in the industry were evident through payment to an extent, but ultimately demands of the Act and the need particularly for robust project management are more important than ever. So it really is something to keep on top of. Those are, I suppose, the main takeaways 25 years on from the enactment of the Construction Act. It was undoubtedly a transformative piece of legislation, which is now reflected across standard forms and broadly in industry practice as well, and has been developed through case law. But there's certainly scope for other major game changers, if you like, in terms of both new legislation and cases as well, and changes to standard forms. So really, when we're looking forward, we're thinking about things like the Building Safety Act, which is incrementally being introduced, and undoubtedly we could have a whole week of sessions on that as well. And I think when we talk about transformative legislation, that's certainly one, and also the sort of move towards climate change provisions to X29 being introduced into the NEC suite, and sort of environmental, social and corporate governance policies as well in contracts. So these are some examples of legislation and standard form contracts changing and evolving, and I think in the near future we'll definitely see more of that as well. So it remains to be seen if the construction industry reacts in a similar way to the Construction Act, but and whether those other changes will be as influential as the Act is 25 years on from them being introduced, but that certainly does remain to be seen. So I think that really sort of rounds off our take on the Construction Act and our key takeaways. I'm going to bring Martyn and Amy back on as well, and I think we've had a few late questions in particular as well. So I think Martyn, you've been manning the sort of questions as and when they've come in. So I'll maybe hand over to you.
Yeah, thanks, Ewan. Yeah, so we've had some questions, but the chat box is still open for anyone else who has any other questions. Just to go back over, I think some folk might have missed at the start, but the slides will be distributed to all attendees of the webinar, and a recording of the webinar is also available on the CES YouTube page if you want to go back and watch any of it. In terms of questions, interesting question on relating to offshore wind farms, and do they fall under the definition of the Construction Act, or does they're not on land? This this particular issue, not in respect of offshore wind farms, but this issue was discussed in the case of Staveley Industries PLC. That was in relation to rather than wind farms, but ultimately the judge held in that judgment that the subcontract for the construction of that the Act wouldn't apply as structures form part of the seabed and don't form part of the land. So the same would apply to offshore wind, and any kind of operation where ultimately the structure is not going to end up on the land. I think the Act's quite complicit in the kind of resting place of the structure has to be within England, Scotland and Wales. I think there was some discussion in that case as well, because the parts of the building that were being constructed were actually to be used outside. I think it was like the Gulf of Mexico there, actually to be used outside the UK. So again, that kind of point was moot, but it reiterated the point that for the structures to, or for the Act to apply to the construction operations, they have to, the building has to end up on the land of England, Scotland, or Wales. And another question, which Ewan touched on in his piece, but to do with the issues around payment mechanism and difficulties in relation to amended or bespoke contracts. So, yeah, what Ewan mentioned, what the Construction Act did do was ensure that this kind of standard forms follow a kind of set payment mechanism. I suppose the issues really come up with kind of standard form T's and C's, which do govern some relationships and do govern some works which are caught by the Construction Act, and they're not always Act compliant. In fact, some of them are very rarely Act compliant. So yeah, it's safer to go down standard form use. You're not going to get caught out by not being Construction Act compliant in that respect. But and what we quite often do, we quite often amend the payment provisions in the standard forms because they're not quite as the market wants them for some aspects. But the difficulty definitely comes where there's just been a kind of a relationship between two companies, and it's kind of standard T's and C's that are used. And in that respect, quite often they haven't been drafted with the Construction Act in mind, whereas the kind of your standard forms, your JCTs, your NECs, etc., they're obviously drafted with their kind of base payment provisions in line with the Construction Act. I think we also had one on adjudication. Amy, if I could pass it on to you. So you mentioned the changes to adjudication during the lifetime of the Act. What are you seeing currently?
I'm going to start with the lawyer's question of it depends. The topics and the declarations are really varied and really wide, and it depends again on what part of the supply chain you're in, whether you're employer, contractor, subcontractor. However, to give you a bit of an answer, we are seeing a trend back to extensions of time and delay claims, a slight pull away from defect claims, although obviously with a lot of cladding issues, etc., we still do see them. I think the extensions of time and delay, I think that maybe mirrors the turbulence in recent years in the industry, and it'll certainly be interesting to see how this progresses, especially like Ewan was saying, with the Building Safety Act and with more of a focus on ESG. I would say there's probably not a slowdown in clients wanting to adjudicate, but what I am seeing is before adjudication, clients are more willing to engage in negotiated discussions or mediation, and sometimes are even willing to consider that after the first notice. What I'd also mentioned during this was that we're seeing less smash and grab adjudications, although they're still out there, but we are seeing quite a rise in serial adjudications, which is lots of adjudications, 5, 6, 7 on the same project, and these are particularly used as pressure tactics, and obviously we've seen that is coming through in the courts, and we're seeing more case law on it. And then finally, I'd be remiss if I didn't mention that we still see all the jurisdictional arguments and challenges in most adjudications, but in practice whether these are actually allowed or agreed or granted by the adjudicators is still pretty rare in my experience. Martin, I think there's maybe a question come in that on escalation clauses and mandatory escalation clauses. I don't know if you're able to pick that one up, Ewan.
Yeah, go for it, Amy. So is this on contracting adjudication? Yes. So to answer that question, I mean, some contracts do require that escalation clauses are mandatory. As I mentioned, as Amy kind of mentioned, the standard NEC does set terms of adjudication prior to tribunal. Sometimes it's unclear, and it's a legal question of contractual interpretation whether you need to comply or not before starting court or arbitration. However, sometimes this comes into practicalities. So for instance, if the parties are approaching a time bar or prescription, then a party will want to protect its position and will likely raise proceedings or file court action, and then look to pause this, or desist or stay, in order for parties to comply with mandatory escalation clauses. However, appears due to recent case law in England and Wales that proceedings could be struck out where non-compliance with the DRP is unreasonable. We've got some kind of materials on that kind of very question. So if you look at some of our law nows, some of our articles on those, you can find some more information on that.
I think on that as well, Martin, will be interesting. I think the new JCT suite of contracts is rumoured to be out next year. I think that the date's been pushed back a couple of years, so sort of in a row, but it does look like it will be next year. So it'll be interesting to see if, with a new suite of contracts being published, if things like this escalation wording does feature in that as well. It will be interesting to see if they do try and bring in this approach that NEC has been pushing for a while to try and bring that into other standard firms as well.
Yeah, wait on bated breath for those GCT amendments.
Oh, definitely. I think rather than delving into anything else, and given the time, I think that's all we have time for today. Sorry if we didn't manage to get to your question. Hopefully you found the session today useful. As we've mentioned a couple of times, we'll be sending the slides round, and you probably saw them flash up, but we do have some materials, some links on the slides for any further reading that you want to do, or any further details there. If you do have questions, then I believe our contact details are on the slides as well. But otherwise, thank you so much for joining, and hopefully see you all again soon.